Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 15 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Welcome back to the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and this is episode 4. Today we are covering cases filed between July 8th, 2020 and July 14th, 2020. Up first is a civil litigation case. In the case of Fulano versus Fanjul Corporation, the plaintiffs are a group of agricultural workers in the Dominican Republic who filed a civil action against a number of defendants. At the trial court level, the court found that none of the defendants were subject to personal jurisdiction in Pennsylvania. The Superior Court agreed and affirmed the trial court's dismissal of the case against all of the defendants. The plaintiffs attempted to argue that Pennsylvania's long-arm jurisdiction statute would allow for personal jurisdiction over each of the defendants. It should be first noted that none of the defendants are incorporated in Pennsylvania, none have a place of business in Pennsylvania, and none are registered as foreign corporations in Pennsylvania. The plaintiffs argued that the defendants placed goods into the stream of commerce that included Pennsylvania. The court held that there were insufficient minimum contacts to establish jurisdiction under the stream of commerce theory. For the details as to why each case lacked personal jurisdiction, the full case is linked in the case note. The next area of law today is contract law. In the case of Szwerc versus Lehigh Valley Health Network, appellant Szwerc is seeking lost wages and attorney's fees following a breach of his employment contract. Ultimately, the appellant was awarded his wages and attorney's fees. This instant case arose as appellant, approximately 6 months after the final order, requested additional attorney's fees. As a general rule, a trial court's jurisdiction, meaning their authority to rule on a case, extends for 30 days after entry of a final order. The appellant argued that the 30-day time bar did not apply in this case because it was brought under the wage payment and collection law, which does not specify a 30-day time frame for requesting attorney's fees. They further argued that they could not have filed the request for fees within 30 days as they did not know whether the other side was going to appeal. The trial court held that Section 5505 of the Judicial Code, which addresses modification of orders and does have a 30-day time bar, controlled. The court affirmed the trial court's opinion that the additional motion for attorney's fees was untimely as it was filed more than 30 days after the entry of final judgment. The lesson from this case is that the 30-day rule for modification of sentence is controlling, even when the statute the suit is brought under does not specify a time limit. The case of D'Amelia versus Toll Brothers, Inc. is brought forth after a decision by an arbitrator following binding arbitration. In a simple and concise statement of facts, there was a litigation between homeowners and Toll Brothers for defective construction of their home. The contract for reparations included a clause that the homeowners would be reimbursed for attorney's fees and disputes would be subject to binding arbitration. Binding arbitration is a form of settlement where the parties to the contract agree to have a third party, called an arbitrator, review the case, and the parties have to accept the decision of the arbitrator. In this case, Toll Brothers contested the amount of the attorney's fees awarded. During the arbitration, they attempted to introduce an exhibit that showed excessive billing on the part of the homeowner's attorney. The arbitrator allowed Toll Brothers to cross-examine on some of the documents included in the exhibit, but ultimately did not admit the exhibit. The arbitrator granted the award of attorney's fees to the homeowners. The court in this case upheld the award, holding that there was no evidence of fraud, misconduct, corruption, or other irregularity in the proceedings, and therefore the award was not unjust, inequitable, or unconscionable. What do we learn from this case? Again, binding arbitration means just that. It's binding and near impossible to overcome absent some evidence of fraud, misconduct, or corruption. The final contract case this week is S&J Baribault versus ZHB of Haverford Township and Haverford Township. This case involves a settlement agreement between landowners, the zoning board, and Haverford Township. The litigation began in 1993. Some litigation occurred, but in 1994, a stay order was issued, and for 25 years, nothing happened. In 2019, the parties negotiated a settlement agreement. The landowners and the zoning board signed the agreement. The township never signed the agreement, but evidence of their acceptance was presented by way of email exchanges between the township solicitor and the landowners' council. The township argued that there was no settlement agreement to enforce because the commissioners had not taken official action. The Commonwealth Court deemed that the statements made by the township solicitor, which were relied upon, were sufficient to establish a legally binding contract, even though the commissioners did not take official action as required by the Sunshine Act. The court found that this technical failure to comply with the Sunshine Act did not warrant the nullification of the settlement agreement and affirmed the decision of the trial court in enforcing the settlement agreement. Up next, we'll take a look at criminal law. First up, the case of Commonwealth versus Rankin. In this case, appellant Rankin was charged with misdemeanor fleeing and eluding and several summary traffic charges. At his trial, the only contested matter was whether or not he was the person driving the vehicle. There were no issues raised as to any other element of the offenses. At trial, Rankin was found not guilty of the misdemeanor fleeing and eluding charge by the jury, yet the judge found him guilty of the summary offenses. Rankin filed this appeal on the basis of double jeopardy and collateral estoppel. Double jeopardy is the constitutional protection ensuring that no person is twice tried for the same crime. Collateral estoppel in a criminal matter involves looking at the not guilty verdict and determining to what extent that verdict would impact future proceedings. In this case, the Commonwealth and the trial court contend that because the not guilty verdict was general and did not include a specific finding of fact, it was insufficient to be the basis for a collateral estoppel claim. The Superior Court rejected this reasoning, citing the U.S. Supreme Court case of U.S. v. Ash, stating that the rule of collateral estoppel in criminal cases must be evaluated with realism and rationality. Where a previous judgment of acquittal was based upon a general verdict, as is usually the case, this approach requires the court to examine the record of a prior proceeding, taking into account the pleadings, evidence, charge, and other relevant matter, and conclude whether a rational jury could have grounded its verdict upon an issue other than that which the defendant seeks to foreclose from consideration. In this case, it is clear from review of the record that the only element at issue during the trial was whether or not Rankin was driving the car. It is clear that the jury based its not guilty verdict on the fact that the Commonwealth did not prove that Rankin was driving. As his driving is an essential element of the non-jury verdicts on the summary charges, the court is collaterally estopped from entering judgment following the jury's not guilty verdict. Therefore, the guilty verdict on the summary charges is reversed. The takeaway from this case is that while inconsistent verdicts are generally permissible, as we discussed last week, collateral estoppel must also be considered. The remaining criminal cases all address the Post-Conviction Relief Act, or the PCRA. The primary issue in Commonwealth v. Larkin deals with filing a PCRA petition with two docket numbers, rather than filing a separate petition for each case with a single docket number on each petition. The case of Commonwealth v. Walker requires a separate notice of appeal for each lower court docket number. Further, the case of Commonwealth v. Crease requires that there must be a single docket number per notice of appeal. Larkin claimed that the procedural misstep by filing a single notice with two docket numbers was the result of the trial court stating that he could file an appeal, singular. The court had previously held in Commonwealth v. Stansbury that such misstatements from the court about how a defendant can effectuate an appeal amount to a breakdown in court operations, allowing the court to overlook procedural defects. The court held that there was a breakdown in operations in this case and the PCRA could proceed despite the defect. The court, however, did find that his PCRA was ultimately untimely and without merit. The concurring opinion agreed fully with the majority opinion and issued an opinion only to address the fact that there is already a remedy when procedural missteps occur. Rule 902 allows a defective appeal to be remanded to the trial court to remedy the defect, thereby eliminating the need to quash a petition simply due to procedural defect. There are two issues addressed in the Commonwealth v. Johnson appeal. The first is the same issue that was addressed in the Larkin case. Does an appeal with multiple docket numbers have to be quashed? In this particular case, Johnson had filed a notice of appeal in each of his four cases, each notice containing all four docket numbers, with the specific docket number for that case in italics. The court found that his defect did not run afoul of the Walker rule, which requires a separate notice of appeal in each case, and here specifically overruled the Crease case, which required a single docket number on each notice of appeal. The actual merits of the appeal presented two questions. First, the brief facts. In these cases now on appeal, Johnson was involved in a robbery that ultimately resulted in the death of a victim. The next day, he was involved in another robbery that resulted in charges being filed in 3 additional cases. On both dates, Johnson carried the same firearm. They used the same vehicle to drive to the scene for similar criminal purposes, and the jacket stolen on the first day was recovered from Johnson on the second day. The two issues raised on appeal were whether joinder was proper and whether there was sufficient evidence for Johnson's second-degree murder conviction. Joinder means that multiple cases are heard in trial at the same time in front of the same jury. Joinder is permissible when evidence of each of the offenses would be admissible in a separate trial for the other offense and could be separated factually so as to avoid confusing the jury. The trial court found that due to the overlapping evidence made joinder appropriate, and the Superior Court found no abuse of discretion or error in allowing joinder in this case. Regarding the sufficiency of evidence, the Superior Court found that the Commonwealth presented more than enough evidence to sustain a conviction for second-degree murder, namely that Johnson's actions resulted in the killing of another human being during the course of committing a felony. The concurring opinion was identical to that issued in Larkin, in that Rule 902 already allows for a defective appeal to be remanded to the court to remedy the defect. We'll be right back after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by The McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
In the case of Commonwealth v. Brown, the appellant Brown filed a PCRA petition alleging ineffective assistance of counsel based on the fact that his previous attorney based his plea negotiations on an incorrect prior record score. Brown accepted the plea, and upon learning that his standard range sentence would be reduced based on his accurate prior record score, he filed this PCRA petition. The PCRA court granted his request for relief and vacated the judgment of sentence, remanding the case for a new trial date. The Commonwealth appealed and argued that because Brown failed to state with specificity that he would have gone to trial and had his counsel not been ineffective, that Brown did not meet the element of showing prejudice. The court found that based on the circumstances surrounding the plea negotiations, the elements necessary had been satisfied. There was no indication that the PCRA court abused their discretion in vacating the judgment of sentence and setting a new trial date, and the order is therefore affirmed. In the case of Commonwealth v. Allison, the court addressed the new fact exception to the one-year time bar to file a PCRA petition. A PCRA petition must be filed within 1 year after the judgment is final unless an exception applies. In this case, Allison was convicted of rape, statutory sexual assault, and corruption of minors. The judgment of sentence was made final on July 25, 2010. Prior to the instant case, Allison filed 3 previous PCRA petitions, all of which were dismissed. In this case, he alleged that he had an exception to the 1-year time bar due to discovery of a new fact. He alleges that the new fact was based on statements made by President Trump and Senate Majority Leader Mitch McConnell regarding uncorroborated sexual assault allegations against Supreme Court nominee Brett Kavanaugh. The court held that the vague and unsupported allegations were inadequate to establish a time bar exception. The court also found that it was proper to dismiss the PCRA without a hearing when the court could determine from the record that no genuine issues of material fact existed. Commonwealth v. Vaux is the final PCRA case this week, this time addressing required notice to dismiss the PCRA petition without a hearing. Vaux raised a number of issues in his PCRA petition, none of which are being addressed in this appeal. What is addressed in this appeal is that the PCRA court dismissed the matter without a hearing and failed to provide proper notice under Rule 907. Rule 907 requires that the PCRA court provide notice of intent to dismiss without a hearing at least 20 days prior to official dismissal. The purpose of Rule 907 is for the petitioner to file his response for objecting to the dismissal. In this case, as no notice was provided, the case is remanded or sent back to the PCRA court. The PCRA court is directed to provide proper notice under Rule 907 within 20 days to allow Vaux an opportunity to object. Following appropriate notice and response, the PCRA court shall proceed accordingly. Moving on to a custody case. At issue in the case of CL versus MP is the disclosure of mental health records during litigation regarding child custody. In the trial court, a guardian ad litem, an attorney appointed to represent the best interests of the child, was appointed and given access to 3 years of mental health records. The trial court record was sealed and only the guardian ad litem was permitted access to the records. The mother filed a motion to exclude the records as their disclosure violated the Mental Health Procedures Act, which only allows for disclosure in very limited circumstances or with written consent. The court weighed this rule with the law regarding the role of a guardian ad litem and the necessity for the records. Additionally, the court found that the confidentiality of the Mental Health Procedures Act could be waived when a party places their mental health records at issue in the case. The majority opinion here found that the mother did in fact place her own mental health records at issue, thereby waiving the confidentiality, and the court complied with precedent, which required the least intrusive methods by only allowing 3 years of records and only allowing access to the guardian ad litem and not the opposing party. In the dissenting opinion, Judge Kunselman disagreed with the majority opinion and the confidentiality of the Mental Health Procedures Act is not waived in this case, and therefore mental health records should not have been disclosed. The dissent further argues that by allowing disclosure of mental health records in this case, the door is now open for argument that mental health records will always be at issue in custody case, which has a distinct chilling effect on parents seeking mental health treatment for fear that it may later be used against them in a custody proceeding. The takeaway in this case is that mental health records will essentially be at issue in every custody case when they can be distributed only to guardian ad litem so as to minimize the intrusion by not providing the records directly to the opposing party. This week, there was an interesting First Amendment case with Commonwealth v. Held, the appeal of TribTotal Media. In the underlying case of Commonwealth v. Held, the sheriff, Held, was being tried for theft and diversion of services based on accusations that he used public employees and resources in his re-election campaign. His trial resulted in a mistrial following a hung jury. TribTotal Media requested disclosure of the names of the jurors. The trial court ordered that the names would be released, but not until Held's case was ultimately concluded. TribTotal Media appealed, claiming that withholding the jurors' names was a violation of the First Amendment. The court held that the delay did not amount to a complete abridgment of the First Amendment right, but was rather an appropriate time, place, manner restriction. The court found that the restrictions were reasonable due to the nature of the case. The underlying criminal case is highly publicized, and the concerns of chilling the jury pool in the second trial were legitimate. The long and short of this case: while disclosure of juror names is required under the First Amendment, reasonable time, place, and manner restrictions are appropriate, and the attendant circumstances of the underlying case are to be considered in crafting those restrictions. The final case of the week addresses an unemployment compensation claim. In the matter of Wells versus the Unemployment Compensation Board of Review, Wells left her job at Highmark and filed for unemployment. Following a hearing with a referee, she was denied unemployment benefits. She then appealed to the Unemployment Compensation Review Board. One member of the board recused, meaning they could not participate in the vote due to bias or lack of impartiality, and without that member's vote, they would not have quorum, which means the minimum number of board members required to vote. The board decided that without quorum, they would not have a hearing and let the referee's decision stand. The Commonwealth Court ruled in this case that the rule of necessity requires that the matter raised on appeal be heard by the board, and the board members must set aside whatever bias would lead to recusal in order to make a determination on the merits. The case was remanded to the Unemployment Compensation Review Board for consideration on the merits of the appeal. Thank you for joining us again this week. I hope the Pennsylvania Case Law Update While You Drive podcast is just what you need to get your work week started off right.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.